we have to have a subject to purchase contract, like what's being used and what you've seen, that we've put together here in Arizona with a subject to addendum. Now, if a realtor's involved, I've put together a wrap financing addendum to accompany our state or Arizona Association of Realtor form to be used in Arizona, so that, hey, if there's a listing agent, if there's a buyer's agent, you can use that form because they have the license to use it. But if, I go find a FSBO somewhere, approach them, I'm not a realtor, and I say, hey, let's enter into a contract, I can't go use the AAR form. It's copyrighted. I have to be a realtor to have a license to use it. So that's probably what you're seeing. With that said, I think it is smart when there's a realtor involved and they have a license to use those state forms.
Yeah. So we have TAR and TREC, Texas Association of Realtors, and then Texas Real Estate Commission. TAR, copyright protected, TREC, not. But I do think.
Yeah. See, we don't have that in Arizona. We either have the state realtor forms or a attorney drafted form. There is no Department of Real Estate form that's out there. And so as a result, you're seeing the contracts that you're seeing, which I'm intimately familiar with. Type of thing. Yeah. What other comments do you have on those? I'm curious. What other issues have you seen with that form as far as it goes with Texas law?
So there's a lot of good stuff in there, and I need to really just bite the bullet and try to make a one size fits all addendum that protects both parties and such. But we just had one come across. Realtor received it as a purchase agreement. And so she called me and I said, uh-oh, I know this. And so I went through it, and there's also a $50,000 liquidated damages clause in there. And so it says, seller, if you end up not doing everything you're supposed to do, you owe me $50,000. And so I knew the agent who had submitted the contract, the one size fits all contract, knew the agent who received it. So I called the first agent back and said, why are you doing this? You can't take a multi-state form or an out-of-state form and just adopt it. You have to cherry pick this, that, and the other. Another clause in there was saying that if I, as buyer, choose not to get insurance, you can't pursue me for that. And we're talking about hazard insurance, not title insurance. And so they're literally saying that they have the right to not get the property insured, which is going to cause the mortgage wrap to fail. So I need to bite the bullet.
Yeah. And of course, different contracts have been adjusted and changed by, whoever's, using them and that type of thing. But which is interesting. Yeah, I agree. I think that,
I've lost hearing.
We lost your sound there, Sean. Wonder if you went muted.
That was weird. I mentioned that QR code. I took a picture of it. Hopefully it's going to work for me too.
So if you're live watching, we're just really having a conversation right now about creative finance. But Alan, and this would be a good time, Alan, to talk about Wrap University. If you're new to creative finance, the wrap transaction is really an integral piece to it. Like I don't even know how I don't think it's recommended to do it without it, but that's a piece that you're going to have to work through. And Alan does the Wrap University. And what we've done, if you're watching, and we've got his website down at the bottom, but we've also done a QR code, Wrap-U for Wrap University, right up there at the top. All you have to do is basically scan that with your phone. The link pops up just like when you were at the restaurant during COVID and we all got sick of having the menus tell us we had to scan the QR code. Well, now you can do it. And instead of order a burger at the COVID restaurant, now you can go directly to Alan's Wrap University. But Alan, why don't you give us a piece on the next upcoming?
You bet. So I'll try to keep it short. we've been working extensively with mortgage wraps and subject to since about 2005 or so. And then I started I want everyone to know how to do mortgage wraps. It's a powerful tool. I want my real estate clients and my real estate investors to know how to do it. So we started with a little 1-hour presentation that kind of kept some folks aware of what the compliance and the disclosure things were. And then I realized, well, that's neat, but they don't know how to do a wrap. So I expanded it. And so there's a live version, 4-hour, just had one this past weekend in Austin. And so we travel around doing the live version, but I realized not getting everyone. So we created an online version, which is really just the 4-hour version, but it has a substantial number of documents included, and then also have monthly meetings of this nature, specifically talking about wraps and sub twos. And I'm hoping to get that wrap forum, the Facebook wrap forum or community, to be substantially multi-state, because just like we're talking about with Sean and I didn't know Arizona had copyright on their promulgated purchase agreements, and so that's kind of stuff that you need to know, especially if you're going to scurry out to that state and start buying properties. I had someone offer a property to me in Alabama, and I was like, well, I don't have boots on the ground lawyer out there, so I had to let it go. So I want to try to create a national network of folks where if someone says, got a property in New Jersey, good. We have 3 or 4 people who are familiar with it. So bottom line, it's just a 4-hour program that should answer every single question that you ever have about mortgage wraps. That's the goal.
John, we're still missing your sound. I don't know what's going on with this.
Oh, there we go. Oh,
hold on a sec. Try it again. No sound. That's weird.
I was looking at the bottom here. There's a dot missing. I don't know if it's important. rapu.ceshker.com, I think. Yeah, rapu.ceshker.com.
Well, we have one comment. Jonathan off of Facebook said, "I just paid for RapU, Alan." So the QR code is working.
Well, good. We have a system to follow up with the students. So he'll get a first email, and then he'll get a direct email from me and my right-hand man, Jessica, because I'm concerned to get feedback. And if there's what's really good about the online program is you can make on-the-fly changes. So I just posted something about handling the escrow account, which we can even talk about the escrow account on here if you want to, because I like to get y'all's feedback on that. But now that document is over in the online program. So it's a living, breathing, growing machine. So that'll be good.
Follow up, Alan. Jonathan off of Facebook has a follow-up question. So he says, in your contracting a wrap discussion, you say that there is no mention of an underlying mortgage. Can you explain? You know what that's like?
Yep, I know exactly where he's talking about. I've only spoken off that slide a couple of thousand times. So whenever you're when you're filling out your purchase agreement, and this isn't good for just Texas, it's national. When you're filling out your purchase agreement, you're going to have a down payment amount. In ours, it's paragraph 3A. Here's the amount we're bringing down. And then we've gotten them to agree to, say, a $250,000 loan. So let's say we're bringing $50,000 down, $350,000 loan. So it's a $400,000 purchase price. If you look at paragraphs 3A, B, and C, there's no mention of an underlying mortgage in that purchase agreement. The entire purchase agreement, all the way up until you get special provisions and you say, hey, by the way, this is a mortgage wrap as a disclosure, it's drafted up 100% like a seller finance transaction without an underlying mortgage. And so what I try to tell people to demystify this creative or complex financing is ignore that there's an underlying mortgage for the great majority of the transaction. The only time you need to know about this underlying mortgage is when you're vetting the project. Okay, $400,000 purchase price. There's $200,000 owed. all right, this, I can handle this. $400,000 purchase price, $500,000 owed. Nope, this won't work. So what I mean by ignore that is a seller finance purchase agreement is going to look 100% like a seller finance wrap purchase agreement, other than the disclosure of the mortgage.
All right, Sean, any luck?
Can you hear me?
Oh man, loud and clear.
Oh, wow. All right. Imagine that.
I don't even remember what you were saying before, but I know it was probably going to cure cancer or something. It was probably amazing.
Yeah, you guys missed out, now.
That's exactly what I was going to say too. I was going to say, man, this is such important stuff coming from him right now.
Yeah, exactly. Hey, so Alan, let's talk a little bit about, drafting the wrap note and the wrap, deed of trust, even mortgage, although I think both Texas and Arizona are deed of trust states. So I use or have my clients use a different note for a wrap acquisition and a wrap disposition. And likewise, I have them use a different wrap note for a wrap deed of trust for a acquisition and disposition. One, and probably the biggest thing is I have a disclosure in the note that is issued or is initialed by the holder, as well as, the deed of trust is missing it, which is there's no due on sale clause on an acquisition. But a disposition, I'm going to have that in there, if you will. And so that's one of the reasons I used a different one. The other is, just the way the financing is structured. I tend to structure it. I allow for on the acquisition note to basically have the buyer, who's the investor generally, make the payment directly to the lender, number one. And if there's a portion of the equity being carried by the seller, then I have a separate payment that the investor could make to the seller rather than forcing them to have a servicing agent. Versus on the disposition, I always am going to have or put in there for a servicing agent. What are your thoughts? Do you have a different note and deed of trust for dispositions and acquisition?
Yeah, absolutely. I'll have the sub 2 documents, and then I'll have the wrap documents. I've actually created another set for if there's an IRA as a purchaser, because it has to be non-recourse. And then I just met with someone today that's going to cause me to have a new set. So you referenced a payment directly to the mortgage company and then a payment to the seller if there's additional. We're calling that a hybrid right now.
Yes.
I don't like this hybrid thing that's going around. It's I don't know if someone got really, really smart and created a new system they could sell, or if someone maybe got too smart and just didn't know they were dissecting a wrap into its two different portions, a sub 2 and an additional equity portion for the seller. So I hate the hybrids. There could be a reason for it if you want to sell one of the notes, which is very rare. But the way you do your note right there, that was a hybrid that you described, is the same way I do mine. There's a sub 2 acquisition portion of my note, and then there's additional dollars of X per month or per year, or a lump sum sometimes. But yes, and I don't have a pen and paper next to me. I need to make a note because you're doing something that's good. Within the note itself, you're stating that the payment's going directly to the mortgage company. Mine actually doesn't have that. And the reason it doesn't is because my sub 2 note has an obligation for the buyer to assume all the obligations of the underlying note, and there's an obligation that he owes this to the seller also. That way, if there's a default, seller can come after them. If I don't have that obligation for them to pay seller, then seller may not be able to come after them in the event of default. But I need to work around that. I'm going to need to get my pen here in a second and write some notes. I'm going to change my documents now after talking with you. And then on the seller finance wrap, absolutely. Consent required, due on sale clause, escrow 100% of the time, all of those things, because we want those more restrictive and strict.
Well, and even on those, so when you were talking about, I don't do two separate notes. So if the seller's going to finance a portion of the equity, I do one note, two components. Right? Yeah, exactly. The subject to performance component, and then the seller, portion that they've financed of the equity goes directly to the seller or the servicing agent. Then they split it up. That's fine too.
Yeah.
But on the disposition, I don't ever break them up into two components on the disposition. And normally the investor is going to finance a portion of that, right? Yep. Unless they take a hefty down payment, but they're going to finance a portion of that. And so in that case, I just do one loan greater than the existing loan with one payment to a servicing agent. And in there, though, it says that and I even have in the deed of trust and the note that the seller, now lender, is obligated or will cause, whether they do it themselves or through a servicing agent, they're going to cause a portion of the payment to be paid to the existing lender. And if they don't, then the buyer/borrower could come in and make that payment and then reduce the amount of their future payments, by that amount, if that makes sense.
Yep. I have that language in there. And interestingly, the Texas State Legislature came in with their new legislation, and they made it a trust issue, trust protection. So let's say I'm in the middle as the investor. All of the dollars I get from that end buyer are now held in trust capacity for that mortgage company. And what they wanted was, if I don't pay, they wanted some toothy breach of trust agreements to come after me. So they did good on that. So yeah, you're drafting yours the same way. I'm curious to see your documents now. I think they're maybe going to be a little bit better than mine.
Let's do an exchange. I don't think they're any better. I think, every time I have an opportunity to see another attorney's documents, there's always something in there where I'm like, oh man, I should add that. That doesn't mean that I've done anything. It's just like, how can I beef this up and just make it a little bit better, every time. So,
and you always can. You can always learn how to make them better. And I think when you stop doing that is when you start getting stale. You start relying on the documents you've had for 20 years. You're going to be out of touch.
Right.
Hey, so a quick note, we do have another question. Wanted to take a brief note for those that have joined us, who came in after we started. Just an idea, just to give you a note as to where we are. We're calling this the collective. This is an opportunity for professionals like Alan, like Sean, myself, and others to participate in a discussion with regard to the areas of creative finance and all the nooks and crannies that are a part and parcel to that, to find out what lawyers are doing in other states, to bring audiences together to find out kind of at a higher level what lawyers are doing, what professionals are doing with regard to creative financing, and give you, the listener, the opportunity to listen, ask questions along the way. So make sure to continue watching, but really make sure to ask your questions, because this is really a unique opportunity to get involved and do it. One note, this has kind of just been an introductory episode. Alan has been gracious to be a part of this with us and is going to be a future participant and member of the collective along with us, in addition to a number of attorneys that we've talked with and have been a part of our program in the past, and we're looking forward to doing that with them. Just a quick note, we're talking about wraps, which is a unique transactional component to what should be almost all creative finance type transactions. A note, Alan owns and operates the Wrap University, and I wanted to make note that there is a QR code right here above the finger that goes right to Alan's Wrap University. You can go right to that. It doesn't matter whether you're an investor, a lawyer. This is a great opportunity to learn more about that. With that, I'm going to jump to another question here. We're getting even more high level from our buddy Jonathan here on Facebook again. And the question is, novating a wrap. Can I? And are there any issues with creating a wrap and then subsequently novating the seller and buyer liens to an investor colleague for a fee. We've got more to this question, but I think you'll forget the beginning if I continue reading. So why don't we start there? If you need me to read it again, I will.
So novations are fun. We in Texas, no, I guess nationally, there's some problems with wholesaling. You can't get it out there on the multiple listing services. Lenders don't pay assignment fees. Title offices are starting to require approval from the seller for a wholesale. So these novations came in, and I'm going to call a novation as the same net effect of as a wholesale, but it gets rid of that inability to list. It takes away that assignment fee, so you're not bothering end buyer conventional lenders. And I shouldn't say this on a publication. Title companies aren't noticing that it's the same thing, and they're not requiring any approval. So if I get something under contract for purchase by cash, seller finance wrap, I can novate that real easily over to an end buyer. In my opinion, I've never thought about it deeply, but I don't see there being any impediment to it.
Yeah. Well, starting with the premise that a novation is a replacement contract. So you're not taking potentially the same terms that you've negotiated with the seller as far as the, seller financing, et cetera. And, basically just assigning those under the existing contract, right? I mean, you're not keeping that contract in place. You're putting a new contract in place. So, novations work well when it's like, I'm just buying it for $300,000. Oh, you found somebody to buy it for $340,000. Okay. I'll release my memorandum or affidavit against the property for $40,000. And I walk away with $40,000 because your contract replaces mine and I'm going to void mine out. And that's what I'm going to charge to do that. Right. So with creative financing, you're basically going to have to find somebody who is going to cash the seller out. So if you enter into a contract, a purchase contract with the seller where you say, okay, I'm going to take over your existing loans, and there's no cash out, it's just simply like a straight subject to, well, now you're going to have to find a buyer who's going to cash them out. And then, your release fee would be basically the difference between, your original purchase price and the end purchase price with what would normally be cash coming to the seller, if you will. Although the cash would never go to the seller, it goes to you as the original buyer, right? Unless you have some arrangement with the seller on a percentage. I don't know. I've never seen a creative finance, a subject to or a wrap deal novated. Have you?
I haven't. But what if the new contract has? So let's say I'm taking it sub 2.
Okay.
240,000. I went out there and found someone who's going to pay above 240, but they're taking it sub 240, and let's say they were willing to pay 270. The 30,000 comes to me. That's the difference between contract 2 and contract 1.
Yeah.
So I can see it being used for that.
Yep. Yeah. You would just need to make sure that the new contract has all of the same, wrap financing terms and all of that as the existing.
I'm trying to think how you could put any more complexity into a transaction than novating a sub 2 to an end buyer sub 2. But
well, there is follow up if you didn't think it could get any more complicated.
All right, we'll see if we're ready.
Yeah. See, well, so given what he said, let me read the beginning again so we have the context again. Novating a wrap, and are there any issues with creating a wrap and then subsequently novating the seller and buyer liens to an investor colleague for a fee? That's what we read before. In the end, my colleague would be on the hook and I would be out. Part 2, could I do the above and keep a cash flowing note for myself?
So my answer is yes, and we've done that before.
Yeah.
We do it in a situation where the deal is tight, and so I was going to get my money via the down payment they were going to bring me the investor, middle investor, the down payment. They can't pay it. We just create a new note. So note A to, I guess what really is just like first lien, second lien lenders. So we've done. The answer for me is yes.
Yeah. You would just create a note for, essentially what would be the assignment fee or even the difference in the, purchase price, and secure it by probably down to a third position deed of trust. I mean, right? Because you have the original existing loan, the seller wrap, and then you would have the third position lien as the middleman investor who's taking a note for the assignment fee instead of, cash.
Yeah, and I've also seen it where the real estate agent's taking their commission on a payout when there's not.
Oh, that's cool.
Yeah, it's helpful
because everyone wonders how the agents are getting paid on sub two, right? And unless the investors, don't lend out cash at closing, but there you go. You could let them take it as a third position lien with regular installments or whatever.
Yep.
I like that.
He had a follow-up. See if this makes sense to you, but it says, here's what I want to novate a wrap. I don't have the collateral to handle a note getting called, so I sell the cash flow.
So that would be exactly what I was talking with that fellow today. So when the acquisition is fine, we don't need to start getting real technical in regards to RMLOs and meeting selling the note compliance type issues. But on the sales side, he creates two notes. One is the amount that's the underlying note, and then the cash flow amount is a second note for him. And then usually the note for the underlying amount is a little bit more. So then when he goes and sells that for 90 cents on the dollar, it's paying for itself. And then the cash flow second note he keeps. So he'll get rid of the problems with the existing mortgage with that first note, and then creates all this cash flow via the second notes. I haven't done that yet, but that's what the guy I met with today, that's what he's doing.
So he's creating, so there's two notes on a disposition that he's basically doing a disposition. The first note is the performance note dealing with the existing loan. And then the second note is the equity that they're cashing out through the sale.
Yep.
And it's that note that they put out onto the market, which makes sense, right? Or is that wrong?
He can sell either.
Yeah. But if you're an investor, you don't really want to buy a performance note because then you're just the middleman cutting the check, right, to the lender.
Yeah.
So you want the cash flowing note only. And if you wrap them into two notes, or not two notes, if you wrapped it into one note with two components, meaning, payments are going to a servicer. I guess if it's going to a servicer, it's fine. And that's the only way you can really sell notes, to have a servicer in place. So I'm kind of answering my own question here.
Yep.
So if you wrap it all into one note, you'd be fine too, because you still are buying the note. The servicer is still cutting the check to the lender and then cutting a check to you for the remaining equity, right?
No, I think once sold, that performance note portion would need to be split up.
Well, I have more context.
Okay, good. Let's go.
Okay.
First note is, I'm just going to read this verbatim. First note is exact wrap. Second note is silent second subordinated to the buyer notes. Buyer note 1 is in second position and buyer note 2 is in third position.
Yeah, that's exactly what this fellow's doing. And
right.
Today he created that term exact wrap, which means subject to. So that exact wrap note is that next one, and then your dollar note. What do you call the second note?
Second note is silent second, subordinated to the buyer notes.
Silent second. Yeah, so that's exactly. It's funny that I don't know if Jonathan maybe was listening to my meeting today with this guy, but that is exactly what we went over. And that was his business model, and so it works for some, but he's going to build up several hundred of these notes and then go and sell all of those performance notes over to a bank buyer. So it's a different structure.
So Andy, it looks like we have some additional folks that have joined the live stream anyway. So for those that have joined, we have a QR code at the top of our screen here, and that's for Allen's Rap University, which is now in an online platform. I had the opportunity of actually traveling to Dallas to attend it in person. And Alan, you still offer some of them, in person throughout the year at different locations in Texas, right?
Yeah. We're going to go around to the 4 main cities, probably each quarter. So we just finished up with Austin, and I think Houston's next, then San Antonio, and then back up to Dallas.
Yeah. So I've been working on creative finance, a significant amount of time, in my view, and yet I know that I was going to be able to learn a lot from Alan by attending Rap University. So I flew to Dallas, spent a day there, and went back and revised a bunch of my documents as a result, which was awesome. So it's definitely something that if you're an investor and you're doing subject to transactions, wrap transactions, definitely you need to attend. Like, it's not even an option. So definitely scan that QR code. That'll allow you to register. You can do it online, or if you prefer in person, you can wait, I guess, for an opportunity that works to do it in person. But why not scan it now, go online and attend and get the valuable information you need to do this transaction the right way. I mean, that's the bottom line.
Yeah, and that's actually what Rap University is about, is doing it the right way, but then, kind of like I said earlier, demystifying it and making it so the contracting is easy for folks. And then, if you don't have to go out and be a sub-2 wrap investor and try to get dozens and dozens of these per year. I think every realtor and every investor just needs to have that arrow ready for whenever the situation arises. You got someone that is real thin on equity, can't pay full 6% commissions. Investor can come over and take that 2.75% note or a 3% note and go over and now monetize that interest rate and create embedded equity and create cash flow, so that that person doesn't end up losing their house because they can't sell it and pay all the necessary closing costs. So just needs to be ready.
Yeah, and what's interesting is not only ready, but I think it needs to be part of every realtor's portfolio of opportunities to create a transaction. And what I mean by that is, my wife and I, we've been trying to secure a second home in Wisconsin, and it's in a smaller town in Wisconsin, and the inventory is just thin to none. And so, we were talking to our agent and saying, well, what's going on here? And his take is, and then I read articles about it too, everybody's holding on to their 3%, loans. They don't want to let them go. And selling the house means that they're now going and getting a 6 or 7%. So they would rather remodel than sell their house. Well, now you have low inventory and high interest rates and high prices because you have this slew of loans out there that came at a very unique time in our economy, where the government felt that to stimulate things, they needed to lower the rates to like we've never seen before and may never see again. And so nobody's wanting to let go of their properties, and nobody's wanting to buy properties at 6 or 7% as well. So, For me, man, how cool would it be if I could know that I could sell my property by doing a subject to transaction or a wrap. I could take some cash out, get the buyer to pay some cash because I have equity. And I could go down the street and buy a different house that's a little bit different, or across town or wherever, and buy a different house and take their loan at 3%. So I'm not at 6 or 7%. And I have some clients who, or not clients, but some sellers that I've seen who are actually, kind of up on this, and they've said, okay, my house is worth, let's say, 500,000, but I'm willing to sell it for 530,000 by you taking over my loan. I'm going to get $30,000 more. You're going to cash me out for $30,000 more because you're about to get a 3% loan. And you're selling it for more than fair market value. And you know what? Buyers are doing it. Sophisticated buyers and sellers are doing this transaction that way. And I think we need more of it. I think we need this to be going on, on a regular, almost like you have your own MLS for just subject to, where can I cash my house out? How can I cash my house out and go and get a 3% loan? Because there's only so many of those now, right? And every time a house is sold and a buyer comes in with a 6 or 7%, that's one more 3% loan that's no more and will never be seen again.
Well, it begs the question too, how long does this trend continue with regard to the popularity for creative financing? And I'm not sure it's really going anywhere anytime soon. I was looking, there was somebody I follow on Twitter, and kind of macro analysis kind of stuff, watching and predicting Fed interest rate changes. And I know that's a topic beyond what we're talking about here, but it's a topic that impacts why we see so much momentum for creative finance, and it's because of high interest rates. And what this post had noticed, and this was yesterday, last month when the Fed raised interest rates again, another quarter of 0.25 jump, the market consensus at the time, kind of almost the betting odds for investment purposes to determine which way this was going and how to invest, was almost universally, well, this is the end. We're going to see a pivot here pretty soon. And just yesterday, those odds are now, they've kind of slowly crept up, but they're already past 30%, that in June, investors have slowly got to the point where they're thinking, well, we think that there's even more of a probability that we might not see a pivot, but even a further hike in interest rates. Again, that's beyond what we're talking about here, but an indicator of, I don't know that interest rates are going to be plummeting anytime soon in the next 6 months, right? We may be in an environment where having low interest rate mortgage is gold.
Yeah. Monetizing your 3% is very popular right now. And you're getting, so usually when you have a increasing market, we had the COVID market, buyers didn't like that. They didn't. And then now the market starts going down a little bit. Sellers don't like that. When you've got people sitting there, you're looking at a 3.25% interest. Seller likes it and buyer likes it. Well, that's gonna push people towards the creative financing, towards a seller finance transaction.
Yeah. If you've just joined us, guys, we're just talking about high-level creative finance things. So if you're watching, we are taking questions throughout the entire hour. So if you have a question for Sean, myself, Alan, all of us, lawyers that are in the creative finance space. Alan is an attorney in the state of Texas. Sean and I are attorneys in the state of Arizona. So we're here to provide as best we can our answers. Another further note, if you're just joining us, Alan is an instructor and the owner of Wrap University, and it is a real option and a vital opportunity for you to learn more about wraps and why they're important. We've got a QR code at the top. You scan that, that'll take you right to his website, and you can be a part of it remotely. This kind of leads me to another question. I think it's worth asking. but I think there might be some disagreement out there. I think you guys probably universally agree on this. But some out there, and maybe even some lawyers, don't even think a wrap is necessary in a creative finance transaction. Well, what are your thoughts on that? Do you think there are times when it isn't necessary, or do you think the wrap is really always the go-to way to transact this?
Well, you want to go first, Sean, or me?
Go ahead.
As an investor, it's always a necessity. If you're an end user seller to an end user buyer, it's a necessity whenever we have the interest rates that we have now. But 2 years ago wasn't really a necessity. I can get myself a 3.25 mortgage, so I don't need to. As an investor, I can only carry X number of loans that I can get, and I forget if it's 7 or 10. Y'all probably know. And then additionally, my credit's going to, debt to income ratios are going to prevent me from having 100 mortgages. But we have several investors here in Texas that have 300 and 400 mortgages under their control, which you can't do otherwise. So I think they're fantastically important for investors and very important now. But there are times where it's not as important in those end user seller, end user buyer situations, is my opinion.
Yeah. Before you go, Sean, Alan, your mic is just a little muted. We can hear you, but it wasn't as loud as before. So you may check that. What are your thoughts, Sean?
So I know there's some attorneys that, some of them are very well respected, and I have a lot of respect for them. But I do know that there's some attorneys that, will use different vehicles to do a subject to transaction besides, the wrap. They'll use, trusts and LLCs, things like that. And I think there are times where that works. In Arizona, that does not, work. So the whole idea behind, putting property into like a land trust is to basically kind of play hide the ball with the lender a little bit, and so the lender's like, oh, they're just doing estate planning, and then you change the beneficiary of the trust, and that's how you transact it. And that works well in some states. In Arizona, if you transfer a property in and out of a trust, you have to disclose the beneficiaries of that trust. Not only disclose the beneficiary, you have to disclose their address as well. So there is no anonymity for trusts in Arizona, and that doesn't work very well. But in my view, and then there's also, and I don't know of any attorney that subscribes to this, but there's, a number of investors that want to do performance deeds in lieu of, notes and deeds of trust and whatnot. And once again, our states have mechanisms that our legislatures have put in place for foreclosures. You start handing off deeds, you're doing an in run around those statutes, plus the statutes that were created for foreclosures also created an order of priority for removing liens against properties. So, you end up with an investor who says, oh, well, here you go, seller, I'll give you a deed in lieu of foreclosure or a warranty deed. And if I don't pay your loan as agreed, you can just run down to the county recorder and you can record that. A year and a half later, I, as the investor, don't pay the loan. And they run down to the recorder, they record it, and they're like, yes, I got the property back, I'm good to go. Only to find out that I, as the investor, my LLC, has 2 judgments against me recorded, or mechanics liens against the property, or other things that an actual foreclosure would have wiped out. It would have, eliminated. And now you have a seller like, oh, great, this didn't work out the way that it was supposed to work out. I just think the way to do a subject to transaction is to follow the statutory mechanisms to provide the wrap or the performance note, deed of trust, and I know you can't do this in Texas. In Arizona, we can do it by like an agreement for sale or contract for deed, do it that way. But, just taking title and giving the seller very, limited or somewhat, in my view, sketchy remedies is not the way to do it. And you're going to end up with litigation and potentially having the transaction, because even a judge is going to look at them like, why'd you do it this way and not, a traditional wrap like has been around for ages. It's just, I just don't like it. I really think that the right way to do the transaction is to follow the statutory mechanisms that our legislature has put into place for that. What are your thoughts, Alan?
My thoughts are I haven't heard anyone say that many different things that I agree 100% with. So we don't have the contract for deed here. We don't have lease purchase option effectively. We don't have rent to own effectively if it's over 180 days and there's a lender.
Yeah.
You can't do those three things. And that hold the deed in a drawer thing is terrifying to me. And I actually had I was helping the buyer. California attorney rolled over and was helping the seller here in Texas, and I said, "Well, let's do a mortgage wrap transaction." And he said, "No, we're going to do one of those lease purchase options. I want to try to protect my client." And I couldn't tell him that he didn't understand the laws of Texas, but he was killing his client. The mortgage wrap is while it may seem complex, and heck, some people even say it's illegal and it's fraud. It's the cleanest, securest way to do a seller finance without paying the underlying mortgage. Period. I don't know. The land trust title companies don't like. They don't work. They don't comply with the Garn-St. Germain Act anyway. So it's still a due on sale clause issue. I don't know if I'm biased or not, but I think the wrap is the cleanest, most secure way for both parties.
What's the argument that it's illegal?
Lack of understanding of the laws. So
right.
You get and I've had real estate attorneys, not just some litigation attorney that doesn't do real estate, come in and look at the transaction and they see that the underlying mortgage wasn't paid off and they immediately think, they rookie-dooed my client. And so I'll get the letter that says there was fraud in this activity and we're going to sue for DTPA. And I have a letter, I call it my 1911 letter. There's 19 notices that it's a mortgage wrap transaction, signed or initialed 11 times. And so those lawyers, I never have a second conversation with them because they go away after seeing that. But some, my dad's a fancy real lawyer, as I say, multi-state, multinational law firm that he owns. And I'll talk to him about these mortgage wraps. And he'll go, "Oh, God, I don't know about that. Due on sale clause." And so they don't get deep enough into it. So it's just lack of understanding and knowledge.
Yeah, more recently, I've studied up on this and given some presentations here locally for real estate agents primarily on this transaction. And what I discovered was, number one, if you go to the IRS's website and you research when you can claim mortgage interest deduction, the mortgage interest deduction, they have a whole scenario on what they call a wrap mortgage. I mean, it's right there in black and white on the IRS's website saying, okay, and then they give a hypothetical and they say, okay, Wendy owes bank A 40,000. Sam purchases Wendy's property for 100,000, leaving the loan in place, giving Wendy and she carries back the equity, giving Wendy a deed of trust for a mortgage or a note and deed of trust or a mortgage for 100,000, but Wendy doesn't record it. And then the question is, well, can Sam deduct the, mortgage interest? And the answer was no, because it wasn't properly perfected in a recorded, lien according to state law. But that was their whole hypothetical, was a whole wrap transaction with the existing loan in place, which is right there on the IRS's website.
Well, and that's what's beneficial. Some investors, hey, the legislature's coming in here with Senate Bill 43 and changing our property code and changing our finance code. This is going to be horrible. And I said, no, this is great. when you have that real estate agent who says, hey, this is an illegal transaction, then you get to immediately say, well, the Texas legislature has given us rules on how to do this correctly, how to make sure we're protecting your client, protecting my client, other client. And so I think it legitimizes it for those who have the misconception of this is illegal.
All right, guys, we have another question. Let's get back into the weeds here. So, question: option to buy back a defaulted seller financed note. Let's say, so hypothetical, I acquire a house and seller finance it to a penalty box buyer at 80% to 90% loan to value. Am I able to create an option in the public record, note, memorandum, mortgage, etc., where if buyer misses 3 payments, I have the option to deed in lieu the property back to me and turn them into tenants? That makes it easier to evict them if they are a nuisance. The idea is not to subvert due process. The idea is for not to get to a point where, let's see, it's a long question, not to get to a point where any due process is needed at all. I'm in Florida, judicial mortgage state. Well, none of us are Florida lawyers, but I'll let you guys handle that.
I think we both have the same answer, don't we, Sean?
Yeah, I mean, at least here in Arizona, now granted, we're not a judicial foreclosure state, but here in Arizona, that, deed in lieu of foreclosure would likely be determined invalid by our court because it wasn't executed at the time of the foreclosure taking place.
Yep. No, that's 100%. It falls back into an executory instrument that's going to be found to be not enforceable if challenged. But in that scenario, did I understand he's selling the note to a third party? So if there's a non-payment, that note owner is going to be coming back over for the foreclosure. So a deed in lieu of foreclosure, I haven't researched it, but I've just been scared enough. I don't deed in lieu it back to a third party. It has to go to the lender. I don't know if it's required by law or not.
Alan, go ahead, Sean.
Well, yeah, and that's interesting. If you're going to sell off the note, how could you have a pre-prepared deed in lieu of foreclosure when you don't know who the end lender is going to be, right?
Yeah. But I don't think it's enforceable if challenged.
Yeah.
If it's not challenged, absolutely all day.
Right.
Alan, somebody's looking for a Corpus Christi lawyer that does sub-2 work. You know anybody out there?
Well, we're in all 254 counties. First off, so we close in Corpus Christi. But if you wanted, a lot of times folks want a door to knock on, sticks and bricks. If they reach out to me, if you Google Ceshker, you're going to find my website. Reach out to us. I've got a bunch of agents that we work with out there, and we can find you a sub-2 lawyer down there.
All right. Alan, your mic's still a little low. I can hear you, but folks are kind of complaining. You were real hot coming in just fine. For some reason, the online messed with it.
I'm not going to touch technology.
if Alan touches anything, we might lose him forever.
I'll try to speak up.
Yeah. Okay. There you go. But yeah, let's see. Yeah, the original question that you guys answered just added some more context. They're just looking for the option to take the property back if the borrower chooses not to pay. Sometimes there's only one option, and that's foreclose. So
you can have a right of first refusal in the event it's being sold. That's easy, but to kind of like Sean was saying, to skirt around the rules and laws and regulations about foreclosure is going to get you in trouble real fast.
Yeah. The courts don't like that. If you're just joining us, I know we've had a few folks. Thanks for joining the collective. The collective is just what it sounds like, a collection of professionals, lawyers who work in creative finance throughout the country. And this is really just our first installment. We've done podcasts with Alan in the past, and we think he's really the go-to guy when it comes to creative finance and wrap transactions specifically. And he's out of the state of Texas. Just a note, in July, we'll be really unveiling the Creative Finance Collective in its full form. And we've got a number of participants all throughout the country that are dealing with creative finance in a variety of different ways and from different jurisdictions and from different states. We're really excited to bring that to you. And what it's going to be like for you, the listener, is really an option to see lawyers and professionals discuss creative finance and get into the weeds on it, and you to hear that, but not only hear it, but participate by asking questions and being a part of it along the way. And we're excited to bring that to you. A couple notes: Alan teaches wrap as part of his creative or as part of his wrap university, and we have a QR code up at the top. You could scan that and be a part of his next wrap university, learn all about doing wraps, and learn about doing what we think is pretty much the go-to important transactional consideration when it comes to creative finance. Let's see if we got any other questions. What else do we have going on?
So, Sean, I'll tell you an item that just came across my desk. An investor purchased sub 2. They reinstated the mortgage, but that did not cause for a truing up of the escrow balance. I don't know why exactly, but bottom line, it didn't. So there was about $8,000 still owed to get that escrow balance back trued up. That investor then foolishly sold the property to an end buyer user, and we drafted up the promissory note. P&I payments is X, PITI payment is Y, and still didn't true up that $8,000 in the escrow account. That immediately got corrected, of course, pretty soon after closing. Shot the mortgage payment up by about, I think, $400 or so per month. And it was on a lower level house. And so it crushed the transaction. And so that investor was trying to save that $8,000. I say that story to say, don't do that. You got to get that escrow account balance trued up really at the time of your acquisition, but you can do it. You can hold off until you sell it, but don't let it go with the property. So that would be my warning for the folks out there.
What would an investor need to do to confirm when they purchase it that escrow balance is at a level that is going to be sufficient and not going to require additional payments at a later date?
So a lot of times folks are using a payoff statement to guesstimate how much the payoff is going to be after that reinstatement is issued, and then where our escrow account is going to be. But you can ask for an escrow analysis, and that's what you need to do. Ask the mortgage company, say, hey, we're going to audit the escrow account, send us that escrow analysis, and then you're using that to get the exact numbers. And you have to do that. If you're reinstating the mortgage on a sub 2 acquisition, you're going to keep it for a little bit. You don't have to do that because you're bringing the escrow account back up to par. But if it's a purchase and a sale real quick like that, you got to true up that escrow account with that escrow analysis.
Do any of your documents require the any of the parties, whether the buyer or seller, to well, it would be the seller generally, if the original seller, the original borrower, do you have a provision in there? I mean, I don't in mine, but do you have a provision in any of your documents saying that, upon request that seller will go and obtain that escrow analysis?
We don't. We do have the authorizations that allows the investor buyer to ask for that. Those authorizations have a time frame. They're going to be good. They'll become stale at some point in time and not effective. I'd have to look through. I know that my documents do have some information in there that if it's called due, they'll work with us to fix that, but not the escrow analysis specifically.
Right.
Yeah. by the time we're all done with this, those documents are going to be, like a conventional mortgage, 120-page loan document.
I know. And that's always the fear, because number one, you put that in front of a seller and they're like, oh my gosh, what am I getting myself into? So you don't want to make it super huge, nor do the investors want it that way. So it's really this fine balance of, how do I make sure that I have everything that I need, but a very small contract? And it's tough.
Yeah.
That's the same challenge with the contracting itself, the purchase contracts. Folks want to use those little simple 2-page contracts, and they're just insufficient. And then others will want to have a 5-page wrap addendum where they're initialing, by every single little paragraph and sentence, and that's overkill. So it's a balance, like you said.
Yeah.
Well, we are at 1 hour. I bet we could, if we weren't watching the clock, continue going forever. But we want to be sensitive to everybody's plans and time. And thank you so much, Alan, for being a part of this with us. A couple notes. We've got the QR code at the top. Join and participate in Alan's Wrap University. If you're doing creative finance and you haven't done that, then you're just not prepared. That's the bottom line. So click on that. It'll take you right to Wrap University. Also, go onto the INREM Podcast YouTube, which is sponsoring this. Like the channel and subscribe. It helps us bring this to you. And we'll be doing this starting in July. We're going to be doing the not the Wrap University. That's always going to be going on. But we will be doing the Creative Finance Collective weekly, and we're going to have a variety of participants. They're going to log in when they can. Alan's going to be with us when he can, to debate, discuss, and analyze creative finance. Anything else you guys wanted to add before we kick this thing?
I appreciate y'all quite a bit, and I'm going to be on every single time I can, because this is what I do. I talk with folks to learn more and more about this stuff. There's always new stuff, so I'll be in every single week that I can.
All right. Thanks so much.
Awesome. Yeah, we appreciate it.
Yeah.
And thanks for coming on tonight, Alan. We really appreciate it. And it was great. I mean, I will be revising my documents tomorrow. So it's awesome. Yeah.
I appreciate it.
So cool.
All right, everybody. We'll see you on the next live stream. Have a good week.